Namaskar viewers, hello and welcome to Sansad TV. I am Tina Jha, you're watching Perspective. On the show today, we will talk about the Supreme Court's ruling on the Prevention of Money Laundering Act, delivering its verdict on a batch of petitions concerning the interpretation of certain provisions of the Act. The Supreme Court bench opined that money laundering is a heinous crime which not only affects the social and economic fabric of a country, but also tends to promote other serious offences like terrorism and drug trafficking. So, upholding the validity of certain provisions of the PMLA, the bench noted that the law was enacted to address the urgent need for a comprehensive legislation to prevent money laundering and prosecute those indulging in activities related to the proceeds of the crime. The court also upheld the Enforcement Directorate's powers relating to arrest, attachment of property involved in money laundering, search and seizure under the PMLA, which were challenged by multiple petitioners. So we on the program will decode the Supreme Court's judgment on the provisions of the PMLA that were challenged and also on the powers of the ED on this edition of Perspective. Joining us is an illustrious panel on the program. With me are two distinguished panelists joining us in the studio. Mr. Karnail Singh, former Chief Enforcement Directorate. Thank you, sir, for your time and welcome to Sansad TV. And Dr. Justice Satish Chandra, former Judge, Allahabad High Court. Also joining us virtually is Mr. A.K. Bhattacharya, Editorial Director, The Business Standard. Thank you, Mr. Bhattacharya, for your time. Welcome to Sansad TV. So I welcome all three of you on the program today. And, let's discuss, let's analyze the Supreme Court's judgment and the implications it is going to have and the kind of course, political responses it has already begun to generate. So, Mr. Bhattacharya, before we begin to talk about the Supreme Court ruling, for the benefit of our viewers, let's get a sense of what exactly the matter was before the Supreme Court, what were the provisions of the PMLA that were challenged, and of course, now that the court has upheld all of those.
This case is something that certainly is a major shot in the arm of the Enforcement Directorate as far as the administration of the Prevention of Money Laundering Act is concerned. Because in many ways, it redefines or repackages as the law exists an earlier order the Supreme Court itself has given, if I remember correctly, in 2017. Wherein there were some questions on the right to bail, as well as what should be the definition of money laundering under Section 3 of the Act should be. What the Supreme Court has done by this order today is actually said, as you pointed out, that money laundering is a heinous crime. It has also made sure that a crucial word has been changed in terms, instead of "and," it has now become "or," which is used to help that it is not enough to have the tainted, money laundered the offense, but also not claim it as something which is tainted. Mm-hmm. Having said that, let me say that it will be seen how the Enforcement Directorate under the current dispensation responds to the various cases that are being looked at by the agency. Clearly, it's a Enforcement Directorate which is now has got stronger. There will be questions about whether the right to bail has been compromised in certain ways. There will also be questions whether this clarification will lead to an improvement in the conviction rate under the Prevention of Money Laundering Act, which right now is about less than 0.5%.
Absolutely. So all of that is something that we will come back and discuss in the course of the program. But coming to you, Justice Chandra, for your perspective, you've been a former judge. How do you interpret the Supreme Court's ruling?
This money laundering, Prevention of Money Laundering Act is quite different from the general criminal law. In general criminal law, there are so many presumptions. For example, that every accused is innocent till proved guilty. But here in this act, the accused will have to prove that he is innocent. So burden has already been shifted to the accused persons. Secondly, the constitutions also prescribed under Article 22 that no arrest can be made without informing the persons, accused persons. But here the PMLA Act prescribed that, and Supreme Court also confirmed that one, that person cannot be need not to be supplied. The FIR means you called it Enforcement Case Information Report. That is the base document on which they start the investigations. So they said it is not necessary to supply this information report to the accused person at the time of arrest. It can be supplied later on. So this is the violation of Article 22, it was alleged. So Supreme Court said, no, you can do it. And that was upheld. And another aspect, that no one can be compelled anybody to become the witness against himself. But under this act, there is a provision under section 63 that information will have to be given, false informations or no information, that will constitute another offense. So this was all these things. So this is different from that act.
Okay, because it involves a heinous crime, all of these provisions that were challenged have been alleged. Mr. Singh, the fact that, the powers of the ED have also been enhanced by this, the Supreme Court has upheld the power to search, arrest, also seizure of all of the assets that come under money laundering. How do you see this strengthening the investigating agency? And this, of course, of late has come under a lot of limelight because of the ways things are happening across the country. For example, the latest being in West Bengal.
See, we have to understand who are the accused in the money laundering case. Most of them are powerful people, money-wise and power-wise. And they could hire the best of the advocates. They went to the High Court and then to the Supreme Court challenging the act itself, saying that this act itself is not constitutionally correct. And therefore, all the provisions of the act, starting from what is proceeds of crime? What is money laundering? That is section 3. The power of search and seizure, section 17 and 18. Even power of attachment, section 5. Then the power of arrest, section 19. The stringent conditions of bail under section 45. The interrogation under section 50. They all have been challenged in this. And Supreme Court has analyzed threadbare all their perspectives and arguments and come out with the conclusion that the act is constitutionally valid. Only one thing is there, the Supreme Court said that if there is no predicate offense, then there is no money laundering. Except that Supreme Court confirmed every aspect of this, and this would certainly help the investigating officer now because they are clear about which provision is there constitutionally valid and where there is a problem. So it will certainly help making people clear, making people lucid that what should they do in the investigation.
I think that is where the concern is, that on one hand, while it is going to strengthen the investigating agency, what is being alleged, and in fact, a lot of opposition leaders are also saying that, if you compare the data, and this is the number that has been put across in Parliament by the government itself, that if you compare between 2004, 2005 to 2013-14, there were just about 104 cases under the ED, which fell under PMLA. By 2014-15 till about 2021-22, this number rose to about 888. But on the other hand, if you compare it to the conviction rate, back in 2004-5 till about 2013-14, 0 convictions. By 2014-15 to 21-22, the case is 23. So while there have been a massive jump in the number of cases under ED which fall under PMLA, the conviction rate has not increased, proportionately. So how do you look at that data, and what is the kind of explanation to this number?
See, number one is when this PMLA Act came into being, the strength of Enforcement Directorate was very less. I'll tell you, in 2015 when I joined as a director ED, we had hardly 600 people against the sanctioned strength of 2048. And therefore, since number of people were less, you would be able to take less number of cases. Since then, the number of people joining, the investigating officers joining the Enforcement Directorate have increased, and therefore they can take more cases. Okay. Secondly, I would explain about this conviction rate. See, conviction rate does not depend upon how many cases you are taking up. Conviction rate depends upon How many cases have been decided by the courts? Everybody is talking about there are so many cases, but only 23 convictions. You know, these 23 convictions are out of the 24 cases decided. And if you take the conviction rate, 23 divided by 24 into 100, it comes out to be more than 90%, which is better than any investigating agencies in the country. Therefore, wrong data has been floated by various people without understanding what is the meaning of the conviction.
Okay, but coming to the political response, Mr. Bhattacharya, you know, of course, multiple petitions were filed, which included, the petitioners included several senior Congress leaders as well. And now the opposition party, of course, alleges, in the first place, their allegation was about political vendetta, and that the ED, at the behest of the government, was targeting only the leaders of the opposition party. Now the allegation is that with the Supreme Court judgment actually upholding the powers, giving, you know, absolute powers to the ED, it is going to increase the possibility of misuse, political misuse, in fact, by the opposition. How valid do you think is that concern? Does it hold any merit?
I mean, it will be unfair to attribute motives to what the ED is going to do. Mm-hmm. In my view, the Supreme Court, which is the apex court of the country, has reiterated and clarified what the statute is actually saying about the law and how it needs to be operated. It is true that the law has given stringent powers to the Enforcement Directorate in dealing with those who it believes to be are accused. But till you see some more cases coming up after this clarification, you cannot sort of form a judgment saying that, oh, ED will now once again go out. Because as Mr. Singh himself pointed out, that out of 24 cases decided, 23 have been convicted. So, and also the fact of the matter is this: even though there are about 160 offenses, scheduled offenses of the law, one has to see that what kind of offenses are these. So I'm not the one to actually jump the gun and say that, oh, this will mean that more such cases will be filed and politically will be misused, used. I think we have to wait and watch to see how this judgment is actually the operative part is informs and influences the actions of Enforcement Directorate in the days to come. I would hope that Enforcement Directorate will be morally get stronger and probably be more responsible in future to use its powers that have been clarified by the apex court of the land.
Okay, Justice Chandra, you know, another fact that's been playing up ever since the Supreme Court, delivered its judgment on the PMLA is that just a few days back, another bench of the Supreme Court had spoken about how we are increasingly, moving towards becoming a police state, and that process is, ultimately becoming punishment. That is a concern that was cited by the Supreme Court. Now, of course, looking at cases under PMLA and which, of course, fall under heinous crimes which impact the economy of the country, which is said to be against the sovereignty and integrity of the country. So, of course, looking at that aspect, this is the kind of judgment that we are discussing today. But in the near future, with the kind of responses that we've seen over the last 24 hours, can it go back to the court for a review? And will the court ultimately also allow maybe a separate bench, maybe a larger bench, allow a review of this hearing?
Look, presently about 4,000 cases are pending for the investigation. And as Mr. Singh told, that staff scarcity is always there and will remain there. So my first suggestion is this, that investigation should be expedited, so that matter can be decided by the court itself, and that will take also some time. Now, coming to your question, that Supreme Court can review it or not. Of course, Supreme Court has the right and has the power to review its own judgment. For example, in this case, Section 45 is dealing with the bail provisions, stringent bail provisions, and in 2017, the matter came up before the Supreme Court. The validity of the Section 45 was challenged in the case of the Nikesh Tara Chand versus Union of India. And there the provision was set aside, struck down, by saying because it has failed twin test. And twin test means two aspects. One is that reasonably there are grounds that he is innocent, the accused person is innocent, prima facie it appears. Secondly, there is no chance that when he will be on bail, he will commit the same offense. So these were the two tests, and Supreme Court said that bail is the rule and jail is the exception. So that section was struck down. In 2000, after this 2017, 2019, the amendment was brought and these two provisions were again restored. Section 45 was restored. And now Supreme Court upholds it. It is valid provision. In 17, Supreme Court said, no, this is not a valid provision, but now in 22, Supreme Court is saying that this is a valid provision. So Supreme Court always has a right to review it and to challenge it or to modify it, its order.
Okay, Mr. Singh, when such cases are before the court and such matters are sub judice, especially before the Supreme Court, the fact that judgments can be overturned, and the example was cited by Justice Chandra. What is it that the ED, what are the kind of problems, the challenges that the ED has to face, especially when we are talking about money laundering? So on one hand, you're saying these are heinous crimes which are not just against the social and economic fabric of the country. They're also promoting serious offenses like drug trafficking, like terrorism, and of which India has been, at the receiving end for long. Drug trafficking, in fact, is a growing menace that we have to nip in the bud. So when we talk about such heinous crimes, and on the other hand, you talk about, curbing the rights, the powers of investigating agencies. How do you balance between the two?
See, we have to work within the framework of law. About this case, particularly this twin bail condition, actually Supreme Court struck down it on the basis that classification of the cases was wrong. The bail conditions were based on the schedule offences, not the PMLA offences, and rightly it was struck down. So amendment was made so that now the twin conditions are dependent upon the PMLA offences, not the schedule offences. And in the PMLA offences also their classification has been made, and that classification has been upheld by the Supreme Court now. So the question is, you have to work, and in that working you have to find out what are the lacunas, whether those gaps can be filled either through legislation or through your working, and that is a continuous process.
As much as I would want to refrain myself from asking, but whenever it involves the investigating agencies, it is bound to, take a political turn because of the kind of, responses and counter responses that you hear from the ruling party, from the opposition party. So the kind of narrative that's built is, that, and right now by the opposition parties, is that the ED has this very selective approach of targeting only, leaders of the opposition parties, whereas those in the opposition who in fact have been served ED notices would not be questioned, would not be investigated once they jump the ship and join the BJP. How do you, and when of course such allegations fly, taken fast, of course, in this kind of political scenario, how does the ED respond to such kind of allegations?
See, one has to see even these cases which are taken up by ED. Have there been no recoveries? There is a large recoveries. Yesterday only in West Bengal some huge amount cash has been recovered. And therefore one cannot say that the people who are being investigated are not involved in the activities. And if they are not involved in the activities, they are courts. Who will give the right decision that this person is not involved or this person is involved? So they have access to the courts, lower court to the highest court. Instead of speaking here, they can go to the court and get the judgment in their favor.
Okay. Mr. Bhattacharya, so looking at how, the ED has been in action and the kind of political responses we are hearing, the larger concern, of course, once again comes back to the absolute power which the investigating agency has. And a lot of, activists, also political analysts have, expressed concern that the Enforcement Directorate with so many powers, with so much powers, can actually become a man-eating tiger in the times to come, and therefore there is need to have some kind of checks and balances. Would you agree that, at the moment absolute power could maybe, could not be fruitful and maybe, turn towards just one side and could be against the other and would be, violating the fundamental rights of the others?
What I would like to see is that while the Supreme Court, having laid down the law of the land in this manner, I I would expect that the Enforcement Directorate would respond to this enhancement of its powers and bridal powers, so to say, with greater responsibility and a commitment to expeditiously clear the cases, in a sense that both the judiciary as well as the enforcement agencies must take it upon themselves as a bounden responsibility that whatever cases are taken up should not be dragging on for years together. Instead, they should find closure at the earliest, because as the Supreme Court also has pointed out, that the process itself should not become the punishment. Instead, when a case is initiated, case is opened, if it is resolved at the earliest possible frame of time, it will be good and it will also be addressing some of the concerns that you're talking about and some of the concerns that the political parties are talking about. So in brief, it is the expeditious settlement of the cases that will address some of the concerns that are being raised right now.
Absolutely, and the kind of importance and the significance, Justice Chandra, that we accord to the PMLA, especially in the dealing with the cases of money laundering, and which, of course, is for the larger interest of the country. Do you think some kind of checks and balances would be feasible in the times to come to address appropriately all of the concerns that have been highlighted?
Madam, this money laundering problem is not in India. This was in the Vienna Convention first time discussed. It was discussed in Vienna Convention. Later on in 1990, the General Assembly of the United Nations passed the resolutions in the cases of the drugs resolutions. And they recommended that every state should pass the Money Laundering Act. And they also prescribed some guidelines for this one. On these guidelines, Act can be passed. Union of India, Government of India has followed those guidelines. And in 2002, this Act was passed, which was introduced in 1999. So 3 years was taken for the study and for all these things. In 2002, when it was passed, then it came into existence. And here I told you the basic document is the Enforcement Case Information Report. And there is a provision for the satisfactory note. And that satisfactory note can be examined by the court. That can be summoned by the court, but ultimately you will have to supply to the accused person, that one. So if there was no ground and no prima facie material, how you can start the investigation or arrest the persons? Because immediately after a satisfactory note, the ED can arrest the persons immediately, or can do the search and attachment or seizure. These are the 4 acts what they can do. So these can be done, and all will have to be in writing, not orally. So the arbitrary use possibility cannot be ruled out, but check and balance is already there, and moreover, if there will be the court will check it, and change is the law of nature. If some misuse is there, then amendment we may bring. Again, to meet out the situations. For example, in Constitution, so many amendments have come.
Absolutely.
To keep updated. So this is the things, and this is the first act which is coming in this line.
Okay, I'll take one final question from Mr. Singh. Mr. Singh, each time the ED comes under fire and the credibility of the institution is at stake, of course, there is bound to be discussion on the kind of checks and balances that are required. But as an organization and as the premier investigating agency, are there internal checks and balances within the institution?
See, Enforcement Directorate has its internal checks and balances. They have internal circulars, how to investigate, who will check what. And secondly, I would talk about the Act itself. The Act provides checks and balances, which has been tested by the Supreme Court in his judgment. See, for example, if you take the case of attachment, the officer has to record the reason for attaching the property, reason to believe. Now, these reason to believe have to be immediately sent to the adjudicating authority. Within 1 month, he has to make a complaint to the adjudicating authority, who has to decide within 180 days whether the attachment done by the Enforcement Directorate is right or wrong. If the adjudicating authority finds it wrong, it can quash it. Even if there is, suppose after the adjudicating authority decision, one can go to the appellate tribunal. So there is a checks and balance. Take for example of search. Again, before going for the search, the officer has to record in writing the reasons for search and what is the material in his possession for which he is, on the grounds of which he is searching. This material is immediately to be sent to the adjudicating authority. And again, within 1 month, he has to make a complaint to the adjudicating authority that I have done this, and 180 days is given to adjudicating authority to decide about this. Take example for arrest. ground of arrest, first he has to record in writing in his file reason to believe that arrest is required in this particular case. What are the grounds? And then he has to serve the person grounds of arrest. It is not that you arrest and don't serve the grounds of arrest. And the next day when he is produced before the court, then the file is submitted before the court. Court can peruse what are the reason to believe on which the officer has arrested him and the grounds of arrest. They can examine. They can examine all the material available in the file and take a decision. Therefore, to say that there are no checks and balances in the Act is an incorrect understanding of the Act. The Supreme Court has gone for each section, analyzed it, and checked whether what are the checks and balances available in the Act. So they are available in the Act, and if any officer violates those checks and balances, there is a court to take care of that.
So there's a robust system with internal checks and balances, and as Mr. Singh rightly said, that it's after the court has gone through each of these instances threadbare, that this ruling that we are discussing on the program today of upholding the various provisions of the PMLA have been upheld by the Supreme Court. So that having been said, I'll have to wind up the program. Thank you, gentlemen, for joining us on the program today, sharing your thoughts, your views with us and our viewers. Absolute pleasure to have you both in the studio, and Mr. Bhattacharya joining us virtually on the program. Absolute pleasure, sir, to have you join us on the program. So that's it from us on this edition of Perspective. Thank you to you viewers as well for your time. I'll see you same time tomorrow now. Until then, take care of yourselves and keep watching Sansad TV.